Thank you, colleagues. Today we begin our study on Bill C-12, an act respecting certain measures relating to security of Canada's borders and the integrity of Canada immigration system, and respecting other related security measures. To open the study, we have the pleasure to welcome, of course, the Honourable Gary Anandasangaree, Minister of Public Safety, and the Honourable Lena Metlege Diab, Minister of Immigration, Refugee and Citizenship. The Minister, accompanied by their following officials from the Public Safety Canada: Shanann Garinger, Senior Assistant Deputy Minister, Portfolio Affairs and Communication Branch; from Canada Border Service, Erin O'Gorman, President of the Royal Canadian Mounted Police; Brian Larking, Senior Deputy Commissioner; from Health Canada, Jennifer Peely, Director, Office of Legislative and Regulatory Affairs, Controlled Substance and Opioid Response Directorate, Controlled Substances and Cannabis Branch; and from Canada's Coast Guard, Brian Tenamenti, Senior Director, Maritime Security Force Development; and from the Immigration and Refugee Citizenship Canada, Jason Hallman, Director General and Asylum. Thank you for joining us today. Mr. Anandasangaree, we will begin by inviting you to provide opening remarks, followed by Mr. Diab to begin with when you're ready. So, up to you.
Thank you, Chair and Honourable Senators. I'd like to start by acknowledging that we're meeting here in the traditional and unceded territory of the Algonquin and Anishinaabe people. I want to thank you for inviting me to speak on Bill C-12, the Strengthening Canada's Immigration and Borders Act, and I want to especially thank Senator Dean for sponsoring this bill. La frontière canado-américaine est la plus longue frontière.
The Canada-United States border is the longest land border in the world and also one of the safest.
The reputation we have created for safety and security, we can always do more to keep Canada and everyone who lives here safe from the illegal trafficking of drugs, humans, and weapons. We must adopt to keep up with the tactics of transnational organized crime groups as they continue to evolve at rapid speeds. That is why Bill C-12, the Strengthening Canada's Immigration System and Borders Act, is so important. As we begin this discussion, I want to keep in mind the following three principles that guide this bill and related public safety policy measures. First, it's charter compliance. Secondly, we've made every effort to ensure that there's due process. And third, that this bill is in line with the Refugee Convention of 1951. Les mesures proposées dans le projet de loi C-12 donneraient
The measures in C-12 would give our law enforcement organizations and intelligence agencies the tools they need to keep pace.
Two themes: securing the border and combating transnational organized crime, including illegal fentanyl and illicit financing. The bill proposes to amend the Customs Act to obligate certain ports of entry and exit to provide, equip, and maintain facilities for any purpose that falls under the Canada Border Service Agency's mandate, including the examination and detention of goods destined for export to match what is currently in place for the import regime. The bill would also amend the Oceans Act to add security-related activities to Coast Guard services, including the ability of Coast Guard assets to conduct security patrols and collect and share information with security and law enforcement partners. It also introduces measures to strengthen our authorities related to immigration documents and information sharing, as well as new measures to strengthen Canada's asylum system by improving the application process. These measures will help ensure the system is not used as a shortcut to regular immigration pathways. I've had the opportunity to speak with several of you who have addressed portions of these immigration measures, including concerns regarding mass cancellation of documents and disproportionality affecting vulnerable groups seeking asylum. I can assure this committee that this does not take away from the ability of legitimate claimants to claim asylum. We have an international obligation to ensure that we are not sending people back to situations of danger. We believe we have the sufficient safeguards in place. Additionally, any use of this power of mass cancellation or change or suspend will have an explanation of why the order is in public interest, who will be impacted, and how they will be impacted. Every time an order will be put forward, it will be published in the Gazette to increase transparency. This is about addressing issues within the system and making certain that it functions in the manner intended. We're streamlining bottlenecks to keep claims move faster. This is something we must do. Related to financing and money laundering, Bill C-12 proposes measures that would strengthen Canada's anti-money laundering and anti-terrorist financing regime, including through stronger anti-money laundering penalties and information reporting and sharing. This is because we know that without money, the transnational organized crime groups cannot function. We need to hinder their ability to get and maintain access to funds. Keeping in mind the devastation that illegal drugs and precursors bring to our communities, C-12 contains measures that would allow law and border enforcement agencies to take swift action to prevent the illegal importation and use of precursor chemicals. It would also ensure strict federal oversight over any legitimate use of these chemicals. And let me just reflect on this for a moment. Over 55,000 Canadians from every one of our communities have been impacted by the fentanyl crisis. Each night, over 20 families go to bed having lost their loved ones. This is one of the major issues we're trying to address. Monsieur le Président, je peux dire que certaines modifications...
Mr. Chair, I can say that a number of amendments to Bill C-12 were agreed to in the House of Commons, particularly in relation to the asylum system.
During the rounds of questioning. Mr. Chair, I would like to take this opportunity to encourage the Senate's support for this bill so that we can implement these important measures to keep our borders and communities safe. And I look forward to questions and comments, also any follow-ups that colleagues here may have. Thank you. Merci.
Thank you very much, Minister. We'll now, of course, invite Mr. Diab to provide opening remarks to be followed by questions. Minister, you may begin when you're ready.
Good afternoon, bon après-midi, Chair Senators. Joined here by my colleague, Minister of Public Safety, and all the entourage that's here. So hopefully we can answer questions to your satisfaction. That's what we would like to do because we really believe in this legislation that we're putting before you. Comme les sénateurs le savent, le système
As senators know, the Canadian immigration system must fulfill a number of roles at once. It must support the economic growth and meet the labor market needs. It has to offer protection to those who face real risks, and it must be fair to a number of requests.
At least I'm speaking on the immigration provisions, and I will leave the other provisions solely to my colleague. And that is to fill the existing gaps in our legislation and regulations so we can ensure we have a responsible, nimble, efficient system that can handle the immense pressure our immigration system is under. Le projet de loi C-12 met à jour un ensemble d'outils.
Bill C-12 updates a number of practical tools that support the Canadian immigration system's functioning, including processing asylum requests, sharing intelligence, and program integrity.
Information sharing and program integrity. Il le fait sans modifier l'engagement du Canada.
It does it without modifying Canada's engagement when it comes to protection, upholding procedures, or equity in decision-making. Pressures under which the asylum system is illustrates very clearly why these updates are necessary.
The system relies on credibility and timeliness. When claims accumulate faster than they can be processed, delays grow and create uncertainty. Le projet de loi apporte également des améliorations pratiques au fonctionnement du système.
Our bill also offers practical updates for asylum seekers. One asylum claim online
Application will improve consistency and eliminate the requirement for applicants to provide duplicative information to multiple organizations, which is exactly what's happening now. By increasing the number of hearing-ready files that we can refer to IRB and removing the abandoned claims, the system can keep its focus on active cases and timely decision. Bill C-12 also addresses how information is shared with federal, provincial, territorial partners. And here I want to stress, this is only domestic sharing, folks. There's no international component to this bill at all. When information cannot be shared clearly or consistently across government, it becomes harder to plan services, manage programs, and combat fraud. During consideration in the House, adopted amendments clarified the limits of document control authorities and strengthened oversight. These included new reporting requirements to Parliament when the authorities are exercised and clear constraints on their use. I think I skipped the page, but that's okay. Amendments also clarified how ineligible claims are handled. So in closing, the immigration measures in Bill C-12, in our opinion, reflect a careful balance. They preserve access to protection and due process. They strengthen the system's ability to function effectively under strained pressure. We also are modernizing information sharing, as I said, between the federal government and provinces and territories. The bill will introduce new document control authorities to manage the documents and the application intake in exceptional circumstances such as fraud, public safety concerns, systemic error, kind of like what happened in COVID. We would have these authorities, which would make life a lot easier. These authorities are not always about canceling numbers of documents. They're about allowing flexibility to adjust when in the public interest, and usually it means to suspend, do what we need to do, and then deal with it, and then go back to it. So I want to thank you, and I look forward for your questions.
Thank you, Minister. We will now proceed to questions. I would like to, of course, to note that ministers will be with us until 5 p.m. today. We'll do our best to allow time for each members to ask questions during the first hour. A second round of questions with the officials will take place from 5 to 7. With that in mind, 4 minutes will be allotted for each question, including the answers. I ask you to keep your questions succinct in an effort to allow as many interventions as possible. And I would also like to ask our two ministers if you can keep your answers succinct so we can get on with the questioning. I'd like to offer our first question to our Deputy Chair, Senator Al Zaibak. The floor is yours.
Thank you, Mr. Chair. And thank you, ministers, for your opening remarks and for being here together with your team to answer our questions. My first question is to Mr. Minister Anandasangaree, related to the security aspect of the Bill C-12. As you know, there have been amendments to the Custom Act to have operators provide and maintain CBSA examination facilities. You mentioned in your speech, in your remarks, it is to ensure alignment with import regime and alignment with other immigration-related matters. But what does that entail for industry stakeholders? Are any new or additional costs incurred to facilitate this change?
Thank you, Senator. It's quite an important question. And let me just speak about the current authorities that exist. We are right now legally able to search both inbound and outbound goods that are coming into Canada and that are going out. However, the current system enables or demands that those goods that are coming in, the service provider, so whether it's a port authority or an actual bridge authority, they have to provide search capacity within their space for us to conduct searches when goods come in. However, the corresponding outbound, so from Canada to U.S., for example, does not exist. So which means that our ability to do outbound searches are somewhat limited. And what we're doing here is to ensure that we close that gap and have more flexibility so we can do both inbound and outbound searches in a more fluid way. As you may know, that some of the concerns outlined by the administration south of the border is that fentanyl, for example, is coming through the northern border, which we categorically deny. However, it's not just about denying, and we also have to demonstrate that we're doing the appropriate level of work, and we have the legal tools to be able to do that work, and that's exactly what this provision does in the amendment, Mr. Senator.
Cost-wise, any
Look,
implications?
cost-wise, there's no direct expenses, but there may be some unintended expenditures that may be borne. Look, ultimately, we're talking about facilities with a great deal of capacity, so we're not asking a small operator, we're asking billion-dollar enterprises to be able to do their part in securing our border. So it is, in my opinion, a long-term investment as part of the ability for port authorities and bridge authorities to be able to do the required work for us to ensure that there's greater safety and security.
Thank you.
Thank you. Next is Senator Karen.
Merci. Ma question touche.
Thank you. My question has to do with immigration. In particular, the wait time of 1 year for the claim to be admissible. Now, this is the first time that I'm seeing a transitory provision that retroactively freezes starting from a bill that was never adopted, so C-12. So this is a C-2 rather. So my question is, what is the intention? Why choose C-2 rather than tabling this bill? Second of all, is it all right? Now, how many asylum claimants are in the backlog? Because we see here about 170,000 annually here in the documents. That's where we're at. So how many asylum seekers are in the backlog? And how many will not be eligible to file a claim because of the 1 year wait time and the retroactive clause?
Est-ce que la traduction fonctionne?
Does interpretation work? There was an interpretation. It was just, okay, I just wanted to make sure that it worked. Allow me to answer in English, if I may, because it's quicker. Yes, of course, it's your constitutional right.
Retroactive to the C2 tabling?
Exactly.
Okay. We needed to have a date, and at that point in time, we feel that we've given notice to individuals that if you really want to claim asylum, you should do it for the proper purposes and don't claim asylum as if you've been here for 2 years, 3 years, 4 years, because that's what we've been seeing.
C'est deux, c'est un autre gouvernement, là.
Pardon?
C'est un autre gouvernement, c'est deux.
But that was a different government, C2. No, it was us. It was ours. It was us. Oh, okay. All right.
Seen a tremendous amount of claims, and many of which are fraudulent claims. So again, the purpose for people claiming asylum under the law is, quite frankly, for those that are fearing, and I'm going to read it, risk of persecution, torture, threats, or on their life, or of cruel and unusual treatment or punishment as described by certain sections of the Immigration and Refugee Protection Act. What we've seen in reality over the last number of years is when people have come to what they perceive, we don't know what else to do, they've started to do that. That has created a lot of, not everyone obviously, but so it has created a lot of strain. What we have seen in the last 1 year, though, is the asylum claims have gone down by 1/3. And largely because I believe not only have we been efficient in what we're doing, but we've also put a deterrent factor to warn people this is not what you should be doing. And many of our claims are inland, which means people that are already in Canada that are either, well, they're here on visas, visitors, temporary students, you know. Does that answer the question?
Just to be clear, I'm not sure you understood my question. I was talking about the backlog and the number of people in the backlog. How many cases are currently waiting to be processed? About 300,000 currently. And how many will the bill allow to remove because of the 1 year period?
Oui, permettez-moi. Oui.
Give me a moment, please.
Oui, on a regardé.
We looked at the claims that we've received from the beginning, the 3rd of June, until the end of October to get an idea of how many were included. It's about 37%, so 19,000 of the 50,000 that we received during that period.
Thumbs up. We're going to move on to Senator. We have two senators who have joined us, Senator Andrew Cardoza from Ontario and Senator Rosemary Mooney from Ontario. So, Senator Cardoza, next question to you, steering member.
Thank you, Mr. Chair, and my apologies for being late. So you might have covered this, in which case you can just tell me and move to the next question. But so I've been working on this. Let me read it to you because I want to get it right. So the bill is called Strengthening Canada's Immigration System and Borders Act. So you are trying to strike a balance between advancing security of Canadians on the one hand, increasing powers of security forces while ensuring the rights of Canadians. That's always the kind of balance you've got to do. So in one sense, this is a timely bill. I would suggest to you that migration around the world is a challenge that's facing virtually all governments, whether it's regular or irregular people who are moving. And I would say that migration has resulted in a right-wing shift in governments and politics around the world, in some cases to the far right. Right-wing is fine, far right, I think, has certain kinds of problems. So if democratic moderate governments don't respond to this one major issue, we end up with moving politics further to the right, further setting back the rights of migrants and people who are moving. So if you can just outline what you think are the key measures on each side of this, where you're tightening up, but at the same time ensuring rights, keeping in mind there is considerable concern that you're moving too far in the direction of tightening up. And I'll ask Minister Anandasangaree first, and then Minister Diab as well.
Thank you, Senator, and that's a very astute observation with respect to where the trends are internationally, and we see that with our Five Eyes G7 partners, and we see it globally as well. I think what's critical for us in Canada is to ensure that we have and we maintain the consensus of Canadians around immigration, and especially with respect to asylum seekers and those who seek protection from Canada. You know, my family came to Canada as refugees, and I will fully appreciate and fully recognize the enormous power that it has given me and enabled myself and hundreds of thousands of Canadians to be able to benefit from this country. But what is important is that we have, and what I outlined earlier was the three principles that have helped us develop this bill. First and foremost is our obligation to the Refugee Convention, which poses a certain amount of restrictions on what our government can do. Secondly, that whatever we do is in compliance with the Charter of Rights and Freedoms, because that's another narrative that's also building, that we can, at will, not have charter protections available. And the third element is due process. I believe the measures that are taken here, especially with respect to immigration, strikes that balance, and it does enable Canada to have a humanitarian system while strengthening certain provisions that appear to be loopholes, and to be able to have what I think are reasonable limitations on, for example, the 1 year limitation for individuals to seek asylum once they're in the country. We believe that strikes the right balance between providing protection at the same time, ensuring that we have some limitations on our system overall.
Do you have half a minute?
You got about
Any time?
20 seconds.
Are you concerned, Minister Diab?
No, if you have a question, go ahead.
Well, my concern is with some of the provisions, are we not going to just end up in court as people push back on some of these measures?
Yeah, look, I go back to the three principles, Senator Cardozo. We believe that we have strike the balance. Virtually every measure that's taken here has procedural safeguards in place. It is charter compliant, and it is in line with the Refugee Convention of 1951. So that is what while, look, every piece of legislation will have scrutiny of the courts. That's the prerogative of those who are seeking that remedy. My sense is that this does secure our ability to withstand challenges to the courts.
Thank you. Next is Senator Kuchar.
Thank you, Chair, and thank you all for being with us today. I have two questions, which I'm going to put into one so I can get them both answered. And they're for Minister Anandasangaree. And they're about the Coast Guard, near and dear to my heart as a maritimer. The Coast Guard will take on now some security activities, and particularly in the north. What is going to be done to ensure that they have the proper kit, proper ships, to be able to do 12-month surveillance in the north? And what is going to be done to ensure that they, if they need to use force, will actually have the capability to use force if needed? Because I understand they're not going to be armed. And the second question is related to the Coast Guard sharing of intelligence with the United States Coast Guard. It's important for illicit drug trade for sure. But POTUS has shown that he's a bit unpredictable. He summarily fired the Admiral of the Coast Guard, Admiral Fagan, about a year ago, claiming she was a DEI hire. And given the fact that we may become the first state, according to him, what's the safeguards around intelligence sharing with the United States Coast Guard?
Thank you, Senator, and I appreciate your concerns about the Coast Guard. And let me just say that this is a very significant shift in the way the Coast Guard is operated. The additional function of intelligence gathering, I think, is critical. It does enable us to secure the 2% commitments to NATO. It also enables us to have greater visibility over the Arctic, especially from an intelligence perspective, because we know that the Arctic is of critical importance not just to Canada but to the world, and particularly I think the Inuit who called it their home for millennia. The balancing act here is that the Coast Guard does not have the ability to do law enforcement. So any type of law enforcement activity, so for example, if it is a customs or CBSA function, then CBSA would have to be embedded within the Coast Guard in order for them to have an active role. And other than transport, they can't really go into the law enforcement lane. So it is a clear delineation. With respect to information sharing, we have a robust system of sharing information, particularly through the Five Eyes. And in September, we met with our colleagues in London, and we will be meeting them again in the summer, the Five Eyes countries. And we have a robust information sharing regime that does enable us to share information mutually, of course, with some limitations and with some safeguards in place. The objective of Coast Guard being able to gather information is about Canada's safety and security, about our fundamental ability to gather information for the benefit of Canada's Arctic sovereignty. And that is the singular and probably the most important reason why that functionality is being expanded.
Thank you, and thank you to everybody for being here, our ministers and a huge support cast. I think just as I start, I would like to congratulate Minister Anandasangaree, for the great team that came to Washington 2 weeks ago to really provide the evidence on the border work. It was good to hear some really specific data, so thank you for that. My question concerns a letter from the Honourable Metlege Diab, the Chair of the National Security Intelligence Review Agency, regarding the government's national security footprint that would result by the passage of this legislation. The letter suggests that the NSRIA is already facing budget reductions under the government's expenditure review, and with this legislation and subsequent expanded government national security footprint, it could not possibly, tough to understand how it would fulfill its oversight role by an acceptable measure or standard. So I'm just wondering what your response might be to these concerns, and if you see a meaningful role for this agency moving forward parallel or with this legislation.
Thank you, Senator, and thank you for the kind words, and I will relay that to the team. Look, the issues around national security does require safeguards in place and what I believe are independent scrutiny of the work of our national security agencies. The work of NCIRA, NCCOP, where as well as the two committees, one of Parliament and one of the Upper House, are critically important tools. The fiscal frame that we're in has resulted in an across-the-board reduction in some cases, including NCIRA, and I acknowledge that, and I've had a number of conversations around it. At the core of this is if there are adequate safeguards in place for an independent review, and I believe it is there, and I believe it is able to do the work that it needs to do, along with the NCCOP, the two committees, Auditor General, and a number of other independent bodies that do the work. The work that we're doing to expand, so for example, right now, Coast Guard is not subject to NCIRA, from my understanding. So the work that we're doing to expand is not currently in the scope of where NCIRA would be required to do the review. Most of the other matters do not relate to intelligence. They relate more to border control, as well as on the immigration side to the Immigration Refugee Board. So I believe the appropriate safeguards are in place. And what I would suggest is that as we look at the national security plan that we intend to bring forward over the spring and this year, there will be additional features around scrutiny and regulation that we will contemplate and we'll be able to share with Canadians.
40 seconds.
Thank you. I think I heard part of, I want to clarify this. Would NCIRA be able to anticipate increased resources to do the work that they need to do as this legislation is passed as it's currently written? Or is that to be determined?
Well, right now they're going through the regular CER process, the Comprehensive Expenditure Review process, and every agency is going through that, save and except frontline officers, so which is CBSA, RCMP, and CSIS. If you look at the Office of the Correctional Investigator, there are a number of agencies, including Public Safety Canada, who have faced some reductions, and that is a government-wide approach, as you're aware, and is one that we need to do in order to strengthen our ability to withstand the current challenges that we face, both south of the border as well as the difficult trade relationships that we have faced.
Thank you.
Thank you, Minister. Next, Senator Osler.
Thank you, Mr. Chair. Thank you, ministers, for being here today. And my question is for Minister Diab, and it's on Part 7 and the proposed changes to the Immigration and Refugee Protection Act. Clause 72 empowers the Governor and Council to cancel or vary immigration documents, including permanent resident status if it is in the public interest. Now, my home province of Manitoba, we have permanent residents who fill persistent labor shortages in high-demand sectors like healthcare, technology, and skilled trades. So typically holding PR status confers security of status within Canada, but this change, along with proposed section 87.302 sub 1, which cancels or varies documents, does make PR status vulnerable to revocation or suspension. And I'm just wondering, what were the reasons that the government decided to apply these new powers to permanent resident status?
We're all talking here and saying the same thing.
Sorry.
No, it's okay. We cannot cancel permanent residence with these clauses, so I'm not sure where you're reading that or what. We'd be happy to look at that, but it's not for permanent residents. This is strictly for those that are here on visa, so temporary, whether it's visitors, but certainly not permanent residents.
Okay, so for clarification, proposed section 87.302 sub 1 to cancel or vary documents, which does actually say permanent resident status. So if there was a matter of national interest, does it make those permanent residents potentially vulnerable to a change in their status?
So the bill itself is not designed to address people's status. We can't take away people's status. That is a matter of right, and people can obviously challenge that. What it does do is it strengthens the control over the documents, the immigration documents, and the application in the inventory when it's necessary in the public interest. So this isn't new. We actually already have a lot of these powers. The difference is we now have to do them one by one. And I learned that when I came as a minister, what they told me, what they did in COVID, they had to do them one by one, which was very time-consuming, inefficient, whatnot. If we can put the powers that are there, what they did during COVID could just have been done at once by suspending, so that it would have been much better, and as opposed to, I guess, telling the pilots or whoever, as what was explained to me, that we had to put the quarantine provisions so that you can't fly over Canada or something of that sort, is what I was being told, in order to get around not allowing people to come into Canada. So that would help us with that situation. The same as if there's a scam in our security features or in our immigration system where there's a cyber attack or so on. We would then be able to stop all inventory and all intakes coming in all at once until that is figured out.
So thank you, Minister. And so perhaps if the department now or perhaps at some point in writing could provide some clarification. I know the previous section does talk about the application process, but section 87.302 sub 1 does make it sound like status could be varied or changed. So
We'll take it back.
that would be wonderful. Thank you for my concerned Manitobans.
So, Minister, just in regard
We'll
to...
take it back.
If you could send the response to the committee chair, to the clerk, we'll appreciate it very much. Next is Senator Hay.
Mr. Chair, and thank you, ministers, for all the work you do for all the people in Canada, not just the Canadians in Canada. I appreciate that. I may be asking a tough question that's likely a worry on people's minds, and as my 88-year-old mom would say, just get it out on the table, so I'm putting it on this table. Minister Diab, stakeholders argue that C-12 could lead to mass deportations without full or fair hearings. And we are seeing what this kind of policy change can do right now in the United States with the federal agents and their treatment of American citizens and acting in a way that's not transparent and against human rights, from basic human rights to the most egregious. So my question is, what safeguards will the Government of Canada ensure that asylum claimants or newly arrived immigrants will receive meaningful procedural fairness through Canadians' immigration system, and that they will have access to judicial review before being potentially removed from Canada?
So thank you. Maybe I will speak here about the pre-removal risk assessment process that is ultimately the one that is in the Act. Of course, prior to people getting on that, they would have probably claimed through other channels as well. They may have claimed, but let me talk about the pre-removal risk assessment, as I alluded to earlier. It's been in Canada for over 20 years, and it has been upheld by numerous judicial reviews as meeting Canada's international obligations. And it was designed in response to our non-refoulement obligations, and not designed explicitly for failed claimants, but rather for individuals who may be removed from Canada who allege that they're facing a risk in the country to which they would be returned. So that process is initiated when a client is no longer eligible to remain in Canada and is subject to an enforceable order. So, an order would have been issued from CBSA that you have to leave, and at that point, that's when if they feel that that there's a sufficient reason that they can say that they're facing a risk of persecution, torture, threats to their life, or cruel or unusual treatment, they are allowed to stay. But that's the threshold they have to face. Even at that point, though, they can still challenge and through the federal court as well.
May just a clarification. Do you see that C-12 could lead to mass deportation in Canada?
So it's not designed for mass deportation at all. There would have to be a public safety issue, as I said. There would have to be a real threat to Canada. Yeah.
If I may be
Yeah.
very clear on this, I would categorically reject that notion. This is not in any way meant for mass deportation. We are Canada. The C-12 reflects the values I think we espouse. Our sense of what we see in other parts of the world has driven how we do things differently in Canada, and to make sure that the right lens, the human rights lens, as well as a humanitarian perspective, is embedded in the legislation. So while I think your 88-year-old mother would be probably right in, appropriate in thinking that what's happening in other places can be replicated here, that's not the case with C-12, Senator.
Thank you, ministers.
Thank you. Next is Senator Ewens.
Merci. Merci, Monsieur le Président. Merci.
Thank you, Mr. Chair. Thank you to the ministers who have traveled here. And I'm happy to know that the Minister of Immigration is here, because today we're talking about security, but with a cross-cutting approach. I'd like to talk about the process. Now, what facts are the studies based on for such an omnibus bill that deals with security and asylum seekers? Now we're talking about acts that have to do with Canada's borders and immigration. What are the threats mentioned in the objectives that justify these measures?
So the bill itself is designed to fill the gaps that the current regulations and legislation and authorities that we don't have. A lot of these measures we already have. It's meant, though, to provide us with more efficiencies and more control over our documents in terms of information sharing. As I spoke, that's one of the 4 sections. It's to be able to share with even in the IRCC division at the moment. When you apply to come in to Canada on a work permit or a student permit, That's one application. You go later to apply for permanent residency. That's a separate one. You got to redo everything all over again. Then if you decide to stay and you want to get your passport, that's a third one altogether. Part of this is to make it all one-line system. So a lot of it is for efficiencies. That's one of the 4 provisions. There are 2 provisions that talk about ineligibilities. I would submit to you those. For me, they're simple in the sense that there's a 14-day requirement if you're coming from United States and you're claiming asylum. After 14 days, we are saying you're not eligible unless you can satisfy the fear of persecution, etc. stage. What we're also saying is we want to tighten up individuals that are in Canada already with visas, regardless of the visa, visitor, you name it, whatever visas. After having been here 1 year, student, whatever, you cannot all of a sudden claim asylum because we need to protect those that are persecuted. That is what our system, that is the fair way to do it. And right now, you've heard, we have 300,000 croissants, in the system. And I'm told 37 of which may be ineligible because of those requirements. So our system is stressed. Canadians rightly are expecting us to take control and to do something. It didn't come overnight, but quite honestly, over the last few years, I would say to you, when I first went into politics over 10 years ago, this was not an issue. In fact, we were crying and wanted people to come. Now it's access, but we still want people to come. The issue is we want them to come properly by using the immigration channels that we have and not improperly. We also want to be able to, those that are committing extortion and crimes and so on, we want to be able to efficiently, with the help of CBSA, say, that's it, we need to move you out faster. And, we've heard loud and clear, we need to do something. And this is our way of responding.
Senator, I realize we're short on time. Chair,
I'll give you about 10 seconds to intervene.
Look, there are a number of measures that are outside of the IRCC world that I just want to highlight, which is on ability of CBSA to do outboard inspections. They changed the Coast Guard mandate, enabling, for example, precursors to be listed faster, measures around border control and removal. So there are a number of measures that relate to not immigration alone, but more to border, as well as directly attacking synthetic and opioids, as well as other illicit drugs, including fentanyl.
Next, we'll have Senator Dasco, followed by Senator Moody, followed by Senator Wu.
Thank you, Chair, and thank you, Ministers, for being here today. Well, there certainly is a lot in this bill to unpack, and when I read the background material, I've got questions all over the place. But I want to start with Part 9 and Part 10 on illicit financing. And so what this bill does, it increases the penalties for certain kinds of crimes. I want to understand the background to this. What is it that has happened? How has the situation changed? What are we trying to accomplish here? What are the goals? And I want to understand a little bit more about who the offenders are. Are they, the terrorist organizations, criminal organizations? Are we talking about foreign interests? Are we talking about foreign elements? Are we talking about foreign state actors, for example? Might they be part of what is in this bill? So that's my first question.
Thank you, Senator. And look, I think it's a very important question. When we had the Five Eyes and G7 meetings this year, one of the terms that came out is polycriminality, and the range of transnational criminal organized crime groups, for example, who are very much, they follow the money. So in terms of whether it's auto thefts, then they follow the auto theft money route. If it's extortion, they follow that. If it's drugs, they follow that. And there's a range of organized criminal groups who use financing as the actual means by which to profit from whether it's human smuggling or migrant smuggling. We needed to have a comprehensive response to that, so that's why we have a range of restrictions coupled by additional resources and additional mandates of FinTrack so that we can actually follow the money and ensure that it's not just police work, and you know that we're setting up a Financial Crime Agency of Canada as part of Budget 2025. It is to ensure that the financing component has the laser-sharp focus it needs for us to use that as an additional tool of law enforcement. And if you wish, I would ask Deputy Commissioner Larkin to maybe comment on it if time permits.
Sure. Thank you.
Thank you, Minister. And Madam Senator, as the Minister alluded to, what we're seeing is a complete erosion of traditional organized crime, an erosion of those that would typically do foreign actor interference, terrorist financing. The term polycriminality is that essentially that crime no longer discriminates. And so that groups operating in Canada will participate in organized crime to support terrorist financing. Vice versa, they will support organized crime activities. And one of the notions for policing of interest is that obviously Bill C-12 does provide some enhanced abilities around proceeds of crime, the ability to investigate money laundering, the ability to seize assets, the ability to recoup, but also enhances our relationship through FinTrack and through OFSI in particular in working with financial institutions. And we've already launched an integrated financing team with financial institutions to advance that work. And so this is important pieces. The old adage of follow the money is that crime can be a lucrative opportunity in Canada, and everybody is looking at different pieces. And so it no longer is, national security looking at this, no longer looking at organized crime. The reality is that we need to take a blended, integrated approach to ensure the safety of Canadians.
So are these offenders domestic? Are they in Canada or working on a transnational basis, or are they mainly foreigners, or who are they? Or both, all of the above?
Yes, no, maybe. But Madam Senator, the reality is that the tentacles of crime knows no geographical boundaries. And so that, to be candid, yes, domestically, we do have domestic those that commit crimes domestically, but we also have those that are globally networked. These are large enterprises that move money across the nation, and that's why the importance of the work with Five Eyes and the importance of working with non-traditional partners is also equally important to the safety, not only of just Canadians, but to our globe and to our partners.
And the recent arrest of Ryan Wedding, I think it's very illustrative of the type of organized crime that we're talking about, which is in this case, more on the Americas side, but very much linked to Canada, the U.S., and Mexico.
Do we have any time?
Next, no, your time's over. Senator Moody.
Thank you. Thank you, Mr. Chair. My question is for the Minister of Immigration, Citizenship and Refugees, Minister Diab. I want to follow up on a question from Senator Carignan. Parts 5 and 6 of the bill introduce a one-year ban on making a refugee claim after the first entry to Canada, including retroactive application. Many legal experts, the Refugee Rights Alliance, the Canadian Council of Refugees, the Canadian Civil Liberties Association, all argue that this could deny protection to people whose circumstances change considerably over time. My question to you is this: what empirical evidence supports this change in the law, and how does the government of Canada address concerns that it violates the rights of these persons? And yes, Minister Anandasangaree, you are correct. We are Canada, and these are values that we hold dear, and not just for Canadians, but for all people on Canadian soil.
Maybe I'll start, Mr. Diab. Look, I think the 1 year bar, which means that.
Not to interrupt, but the message, it was directed at Minister Diab. I'd love to hear your thoughts after.
Okay.
Thank you.
So you're talking about the section of the bill that talks about the ineligibilities, and particularly with the ones that are affected for the 1 year, perhaps. They, as I said, they will have access to the pre-removal risk assessment before they are removed from Canada, and that application suspends the removal until the IRCC renders a decision on the risk a person may face. So they will not be removed until that takes place.
Process, Madam Minister, but I am asking about the empirical evidence that supports the change in this law. If you could focus on that, that would be helpful.
Jason, do you have? So we have stats. Jason, can you perhaps?
Yeah, I would say that we focus on the pre-removal risk assessment because it is a key tool to ensuring, as the Minister mentioned, that people are not sent back to situations of harm or danger. And in that sense, it looks at the same types of criteria that the Immigration and Refugee Board does in the claims that are before them. The pre-removal risk assessment, it would be artificial to compare the approval rates of those because obviously right now, largely the people who have access to the pre-removal risk assessment are people who've already failed an IRB decision, and therefore the new evidence that they provide doesn't really lead to a different decision. But really what we see is that the mechanism, as the Minister said earlier, is a 20-year-old kind of process. It's been subject to significant judicial scrutiny over that time and always been upheld. Only about 5% of the cases that go to the federal court are either returned for review or are settled. So we're pretty confident in the approach. The officers that we have making those decisions receive about 6 months training and mentoring in order to ensure that they have the skills to make the decision. Each case is reviewed on its own merits, and the clients are providing the same type of information that they provide to the Immigration and Refugee Board. And that information can be continuously updated by the client right up until a hearing. So should they have new information, should they want to continue to work on their case, they can be supported by an attorney or legal aid in the same way they can at the Immigration and Refugee Board process. So
I'm going to give you one stat that was just passed to me, and I actually knew that, but just to show you how concerned we are. Over the last year, 37% of the asylum claims came from students.
I know we would have some more questions, but I have to move Senator Wu.
Thank you, ministers and officials. My understanding of the system as we have it today is that the IRB was created precisely because of a Supreme Court decision, Singh versus Canada, which found that it was necessary to have an in-person and oral hearing before an adjudication panel. This is the same question we're going through again today. So I don't understand how you can tell us that this is charter compliant when the Supreme Court has already said that it isn't.
Do you want to? We have a justice, someone here from Justice that can actually answer that if you like.
I can answer this.
I prefer to hear from one of the ministers.
Look, I think, look, we have to be clear, I think, in terms of where we are today vis-a-vis our refugee determination process. It is, right now, bursting at the seams, I think, is an understatement. It is significantly slower because of the volume that we're dealing with. It is unfair, patently unfair for people who are going through this, who have faced trauma, who have been in the system, who, where it may take 6, 7, 8 years for them to reunite with their family. That's the premise we're approaching this with. So when you're in Canada, you have a year to make a claim, which is a reasonable time. It is not 10 days, it's not 14 days, it is 1 full year. And while, like I would say, most people who come in through the border will have to make the claim on the day that they come to the border. Those who are arriving by flight, for example, many of them will make the claim right away. What we want to make sure is that that ability to file that claim to seek asylum is available. And 1 year, yes, it is a number that, you know,
Sure.
it's somewhat subjective,
yeah.
but it is a reasonable period of time for somebody to make the claim. So those people will get the full benefit of the Immigration and Refugee Protection System. For those who face significant challenges, so for example, I'll say issues around LGBTQ members of the LGBTQI communities, if they come in, there is a risk for their safety and security upon return, and they make the claim after the year when they're ineligible. The safeguard is the pre-removal risk assessment. So when it comes through the system, through the IRB, through appeals, the PRA is a very low acceptance rate. When it is the first instance, it is the actual determination piece without any other mechanism in place, whether it's IRB or any other form of determination, it's far higher. It's in the 60 percentile range.
Yeah.
So, look, I think it's a compromise we've had to make, but it is still grounded in principle. So while the Singh decision, I think, is a critical guiding principle of refugee protection in Canada, it is, in this context, what we're dealing with, it is an important step to ensure that our system is fair, it's more efficient, but also absolutely humane in terms of those who may be impacted.
Well, it sounds like you're going to let the courts decide if and when somebody makes a challenge, and of course it's going to take time and money and people are going to get hurt. And your argument to the Supreme Court essentially is that the world has changed. We need to be expedient. We've got a huge backlog. Therefore, we think you should this time make a different decision.
No,
what is the
that's
argument?
not correct.
What's the
Senator,
argument you're going to make to the Supreme Court?
The argument to the Supreme, I mean, I'm not a Supreme Court, like, I know the lawyer who did the Singh decision, and I have the utmost respect for her. She's one of my mentors. But what I will say is that the legislation in front of you today has the safeguards in place, ensures a better and more efficient immigration refugee protection system, and also will make sure that people do not fall through the cracks. And that's why the PRA, which is automatic in this case, will be provided.
Thank you.
So I will just add on that we actually have received, that courts have confirmed neither the Charter nor the Refugee Convention requires a particular form of refugee determination process. Therefore, as long as those with ineligible claims are given access to a risk assessment, which we're saying the pre-removal risk assessment that we have is there, this proposed ineligibility provision would be found compliant with Canada's international refugee obligations in Section 7 of the Charter.
Can you provide us with those rulings? That'd be very helpful.
Well, I mean, that's the information that I have from, experts from departments. But sure, I believe we have filed a charter when it was first tabled, when the law C-2 was first tabled back in June.
Colleagues, we are approaching the witching hour, which is almost 5 after 5. And so I want to thank all of you for your very thoughtful intervention in regards to our ministers that are here today. Minister Diab, I know my colleague on SOCHI, I know they're hearing sections of the bill more specific to the immigration changes.
I don't know. If you say so, I'm not sure.
No, I'll let me finish here. They certainly have asked you to appear before that committee as they are dealing with the bill, and I would urge you to, of course, to consider appearing to that committee, because they are, of course, having far more witness on the immigration side of the bill that requires, obviously, your leadership to speak to their issues that they may want to have. Both ministers, thank you very much, of course, for being here today. This is an opportunity for us, of course, a very complex bill as we go through the process. but we thank you for taking the time to be here. Mr. Anandasangaree, please.
Sure, Senator. Thank you for this opportunity, and thank you again to Senator Dean. What I will suggest is, I've had a lot of one-on-ones with senators over the last year or so, or 9 months. I would invite you to, connect with my office or Mr. Diab's office. I'll be more than willing to sit down and go through any provisions, any concerns that people have. We recognize it is a complex bill. It's multi-layered, many different dimensions to it. So we appreciate the complexity that all of you are working with. And for my part, I will be more than available. If you P9 me, personally, I will be able to get back to you. Thank you.
Thank you so much. We'll take a brief recess, and we'll start with